All right. How come it's not letting me? Oh, okay. All right, good evening, everybody. And tonight is March 24th. We are on volume 6, Understanding the UCC. And we have one more class we're going to do next week. If you are enjoying our videos, please make sure to subscribe, like, and share. And also, if you are interested in joining the next class that we're going to have, it's for members only. It is the family office. That is your phase 0, where you want to get started after the free live courses of the foundations and risk literacy class. Definitely join our website at www.privatepathhrsolutions.com and become a member. That way you can register for the classes. And we hope to see you there. We have limited seating, so make sure you get that going. And classes will start April 7th at 5 p.m. on Tuesdays. And we're going to go ahead and get started with tonight's class. Narrator, take it away.
Understanding the UCC, Volume 6, Commercial Notice, Secured Interests, and Why Most Filings Fail. Important notice, scope and intended use. This ebook is part of the Private Foundations and Risk Literacy series. The live YouTube sessions associated with this series are provided for general education literacy only and are designed to help viewers understand administrative systems, terminology, and common sources of confusion. This ebook goes beyond the scope of the live sessions. It contains structured analysis, sequencing explanations, and reference material that is not presented publicly and is intended solely for members who have agreed to private membership association terms. This material does not provide legal advice, tax advice, or instructions for filing. It is designed to support informed decision-making and reduce harm caused by misunderstanding administrative processes. Private membership use only. Access to this book is limited to members of the Private Path Private Membership Association who have completed the membership application, agreed to the association agreement, and executed the non-disclosure agreement, NDA. Redistribution, excerpting, or use of this material outside the PMA is prohibited. This restriction exists to ensure that the material is studied in its proper context and is not misapplied, misquoted, or used without adequate foundational understanding. The YouTube series teaches literacy. The ebook exists so students don't misapply what they learn. Private Membership Association Notice. This publication is a private educational resource made available exclusively to members of Private Path HR Solutions Private Membership Association, PMA. Access to this material is conditioned upon acceptance of the PMA membership agreement and non-disclosure agreement, NDA. Use of this publication is limited to personal educational study by authorized members. Unauthorized sharing, reproduction, distribution, or commercial use of this material, whether in whole or in part, constitutes a breach of private contract and may result in remedies available under the PMA agreement, including termination of membership and pursuit of contractual or civil relief where appropriate. Disclaimer and educational notice. This ebook is provided for educational and informational purposes only. It does not constitute legal, tax, or financial advice, and it should not be relied upon as such. The material in this publication is based on private research, historical references, and educational analysis, including concepts taught by Patrick Devine as interpreted and expanded upon by Private Path HR Solutions. The purpose of this work is to explain administrative classification, presumptions, and common sources of misunderstanding, not to instruct readers on filing, compliance, avoidance, or legal strategy. Readers are solely responsible for their own decisions, actions, filings, and outcomes. No guarantees, express or implied, are made regarding results. For matters requiring professional judgment, readers are encouraged to consult a qualified licensed professional in the appropriate jurisdiction. Copyright and use restrictions. Copyright 2025 Private Path HR Solutions PMA. All rights reserved. No part of this publication may be reproduced, stored, transmitted, or distributed in any form or by any means without prior written permission, except for brief quotations used for private study or commentary within the PMA. References to government agencies, including the Internal Revenue Service, are descriptive and educational only. Nothing in this publication instructs or encourages evasion of lawful reporting or compliance obligations. Contact us. If you have questions, need guidance, or wish to access additional tools and consulting, our website is www.privatepatHRsolutions.com. Email is privatepatHRsolutions@gmail.com. For classes, classes@privatepatHRsolutions.com. Instagram and TikTok @privatepathr. Private membership access available through our site. Introduction. Why this volume exists. At some point in private study, attention shifts from identity and systems to paperwork. People begin to hear that filings matter, that notices change posture, that recording something in the right place creates authority, protection, or leverage. The Uniform Commercial Code often appears at that moment, framed as a mechanism that turns knowledge into power. This is where confusion accelerates. The UCC is real. It is widely used. It governs enormous portions of commercial life. And it is one of the most misrepresented frameworks in modern private education. This volume exists to slow that conversation down before misunderstanding hardens into action. The problem with how the UCC is commonly taught. Most people are introduced to the UCC backward. They're shown filings before governance, articles before scope, outcomes before conditions. In that inversion, the UCC is treated as a tool for asserting authority rather than a framework for organizing commercial relationships. As a result, filings are mistaken for claims, notices are mistaken for commands, and paperwork is mistaken for money. This volume corrects that inversion. What the UCC actually is. The Uniform Commercial Code is not a court override. It is not a sovereignty declaration. It does not create assets, discharge debts, or transform identity. It is a standardized body of commercial law adopted by states to govern specific types of transactions between parties who already have standing to transact. Its purpose is predictability, not leverage. Understanding that purpose changes everything that follows. Why this matters before any filing is ever considered. When the UCC is misunderstood, people file documents that have no effect, create records that work against them, or assume protections that do not exist. Most of these actions are taken in good faith, guided by confidence rather than comprehension. The cost is not always immediate. It shows up later, when filings are ignored, dismissed, or interpreted in ways the filer never anticipated. It shows up when people realize that repetition did not create authority, and that the system responded exactly as designed. This volume exists to prevent that outcome. What this volume will do. This volume will explain how the UCC is structured and why articles are not interchangeable. The difference between Article 1, Article 3, and Article 9. What secured interest actually means and when it exists. Why filings do not create money or eliminate obligations. Why filing against oneself is legally meaningless. When UCC filings are legitimate and when they are reckless. The focus is not on how to file. It is on understanding when filing makes sense at all. What this volume will not do. This volume will not provide scripts, templates, or filing instructions. It will not encourage speculative claims, performative notices, or filings made for effect rather than substance. It will not promise outcomes the UCC does not support. This is not a tactics volume. It is a literacy volume. How this volume fits the series. Volumes 4 and 5 address two major sources of preventable harm: premature action and misinformation. Volume 6 addresses the next risk layer: misapplied commercial process. Together, these volumes are designed to stabilize understanding before any advanced discussion of enforcement, contracts, or commercial remedy ever occurs. If you approach the UCC with clarity, it becomes predictable. If you approach it with assumption, it becomes dangerous. This volume is here to make the difference unmistakable. What to expect going forward. The chapters that follow will move deliberately. They will explain scope before authority, purpose before process, and structure before consequence. Each article will be addressed on its own terms, without collapsing distinctions or implying power where none exists. By the end of this volume, you should not feel closer to filing anything. You should feel clearer about why most filings fail, and why restraint is often the most commercially sound position available. That clarity is the point. Chapter 1, what the UCC governs and what it does not. Introduction. The Uniform Commercial Code often enters the conversation surrounded by expectation. People hear that it controls commerce and that it can be used to assert rights, or that filing under it changes one's legal position. Those ideas feel plausible because the UCC does govern important aspects of commercial life. The problem is not that the UCC is insignificant. The problem is that its scope is misunderstood. This chapter exists to establish that scope clearly, before any articles are discussed and before any assumptions take hold. The UCC framework, the UCC is a framework for certain commercial transactions. The UCC is a standardized body of law adopted by states to create consistency in specific types of commercial transactions. Its purpose is predictability. It tells parties who are already engaged in commerce how rights and obligations are treated when certain conditions exist. The UCC does not create commerce. It does not create parties. It does not manufacture rights where none exist. It governs relationships that are already present. This distinction matters because many misconceptions arise from treating the UCC as a source of authority rather than a set of rules applied to qualifying activity. Governance requires a qualifying transaction. For the UCC to apply, there must be something to govern. That something is a qualifying transaction, an exchange, an instrument, or a secured relationship that fits within an article of the code. Without that underlying reality, the UCC has nothing to attach to. This is where many filings fail. Paperwork is created without a transaction. Language is asserted without a relationship. Notices are sent without a governing context. The result is silence, not because the system is hostile, but because there is nothing for it to process. Where modern teachings drifted. Patrick Devine emphasized understanding systems before interacting with them. He spoke about commerce as a domain with rules, not a magic lever. He did not teach that the UCC could be used to bypass courts, negate statutes, or manufacture standing. Later interpretations shifted that posture. The UCC began to be framed as a tool of assertion rather than a framework of governance. Filings were treated as declarations. Notices were treated as commands. The presence of a code section was mistaken for authority. That shift created confidence, but not competence. Why scope is the first literacy test. Understanding what the UCC governs prevents nearly every downstream error. When scope is clear, articles are read correctly. When scope is clear, filings are contextualized. When scope is clear, restraint becomes obvious. Without scope, everything looks like it should work. With scope, most speculative uses dissolve on their own. This chapter is not about discouraging study of the UCC. It is about restoring the order in which that study must occur. Closing. The UCC is powerful precisely because it is limited. It brings clarity to define commercial relationships and predictability to qualifying transactions. When it is treated as something else, as a universal override or a source of authority, it stops making sense. This chapter exists to anchor the rest of the volume. With scope established, the articles can be understood on their own terms rather than projected onto situations they were never meant to govern. In the next chapter, we will look at Article 1, where definitions and general provisions are often mistaken for grants of power, and why that misunderstanding leads to false confidence. For now, this distinction is enough. Before asking what the UCC can do, it is essential to know where it applies. Chapter 2, Article 1, General Provisions and Why Definitions Matter. Introduction. Once people learn that the UCC has limits, attention often shifts to its language. Article 1 is usually where that attention lands first. It contains definitions, general rules of construction, and principles that apply across the code. Because it speaks broadly, it is often mistaken as foundational authority rather than contextual guidance. This chapter exists to correct that misunderstanding. Article 1 does not grant power. It frames interpretation. Article 1 sets context, not authority. Article 1 establishes how the UCC is meant to be read. It defines terms, explains how provisions relate to one another, and clarifies general concepts like good faith, notice, and reasonableness. These provisions help courts and parties interpret the rest of the code consistently. What Article 1 does not do is create rights on its own. Definitions do not operate independently. General principles do not stand alone. Nothing in Article 1 applies unless another article already applies. This distinction is often missed, leading people to treat definitions as operative tools rather than interpretive aids. Why definitions are commonly misused. Definitions feel powerful because they appear absolute. When someone reads a definition of person, security interest, or value, it can feel like the code is recognizing their position simply by naming it. In reality, definitions only explain what words mean when they appear in applicable provisions. A definition does not pull someone into the UCC. It explains how the UCC speaks once it already applies. This is where many modern teachings go wrong. They extract definitions from context and present them as standalone authority, creating the illusion that naming a term activates the code. It does not. Good faith, notice, and reasonableness in context. Article 1 includes concepts that sound ethical or procedural, such as good faith and notice. These concepts are often misinterpreted as requirements imposed on the world at large. In practice, they function differently. Good faith governed conduct between parties already engaged in a transaction governed by the UCC. Notice explains how information is treated within those relationships. Reasonableness sets standards after applicability is established. These concepts do not obligate third parties to respond. They do not compel agencies or courts to accept assertions. They guide interpretation once the code is properly in play. Where confidence replaced comprehension. Patrick Devine emphasized careful reading and restraint. He did not teach that definitions could be wielded as leverage. His focus was on understanding systems well enough to avoid misusing them. Later interpretations flattened that nuance. Article 1 was presented as a toolbox. Definitions were treated as switches. The careful sequencing of applicability was replaced with the idea that invoking language was enough. This shift produced confidence, but not alignment. Why Article 1 must be read last, not first. Although Article 1 appears at the beginning of the code, it is best understood after the relevant substantive article. Article 3 explains negotiable instruments. Article 9 explains secured transactions. Only then does Article 1 clarify how terms are interpreted within those contexts. Reading Article 1 first often leads to projection. Reading it after scope and substance leads to clarity. This chapter restores that order. Closing. Article 1 does not open the door to the UCC. It explains what the room looks like once you are already inside. When definitions are treated as authority, confusion follows. When they are treated as context, the rest of the code becomes far more predictable. With this distinction in place, we can now turn to one of the most frequently misunderstood areas of the UCC, Article 3 and negotiable instruments, where paper, promises, and value are often conflated. That is the focus of the next chapter. For now, this principle holds. Language does not activate law. Applicability does. Chapter 3, Article 3, Negotiable Instruments and the Limits of Paper. Introduction. Article 3 is where many misunderstandings accelerate. This is the part of the UCC that deals with negotiable instruments, documents that can be transferred and enforced under specific conditions. Because it involves paper, signatures, and promises to pay, it is often assumed that any document that looks official or contains monetary language qualifies. This chapter exists to slow that assumption. What Article 3 actually governs? Article 3 governs negotiable instruments. That phrase has a precise meaning. A negotiable instrument is not simply a document that mentions money, obligation, or debt. It is a narrowly defined instrument that meets specific criteria under the code. It must be an unconditional promise or order to pay, a fixed amount of money, payable to order or bearer, payable on demand or at a definite time, and not subject to additional undertakings outside payment. If those conditions are not met, Article 3 does not apply. This is not a matter of interpretation, it is a matter of definition. Why most documents are not negotiable instruments. Many documents reference money without creating negotiable instruments. Contracts establish obligations but do not automatically qualify. Invoices request payments but do not meet Article 3 criteria. Court judgments order outcomes but are not instruments designed for negotiation. The presence of a dollar amount is not enough. The presence of a signature is not enough. The presence of official formatting is not enough. Article 3 does not govern important papers. It governs a specific class of financial instruments. When that boundary is missed, paper is mistaken for power. Promises, paper, and the illusion of value. One of the most persistent myths surrounding Article 3 is the belief that creating or endorsing paper can generate value. This belief often takes the form of assuming that promissory notes, drafts, or self-created instruments can be used to discharge obligations or compel acceptance simply because Article 3 exists. In reality, Article 3 does not create value. It governs enforcement after value already exists and after a qualifying instrument has been properly issued. Without an underlying transaction and acceptance by parties capable of negotiation, the paper has no operative effect. The code does not reward creativity. It responds to structure. Where modern teachings drifted. Patrick Devine spoke about instruments in the context of commerce, not invention. He did not teach that people could manufacture negotiable instruments through paperwork alone. His emphasis was on understanding how commercial systems treat existing instruments, not on creating substitutes for them. Later teachings blurred this distinction. Paper was elevated. Signatures were emphasized. Language was treated as activation. Over time, the idea took hold that producing a document could force recognition. Article 3 does not support that idea. Why Article 3 is often overestimated. Article 3 feels powerful because it deals with transferability and enforcement. But that power is conditional. It applies only when the instrument already qualifies and when the parties involved are operating within the commercial framework the code governs. Outside that context, Article 3 is silent. This is why many attempts to rely on Article 3 result in no response at all. The system is not resisting. It simply does not see a negotiable instrument to process. Closing. Article 3 does not turn paper into money. It explains how certain instruments behave once they already exist. When this distinction is understood, much of the mystique surrounding negotiable instruments disappears. This chapter does not discourage study of Article 3. It places it where it belongs, within a narrow, defined commercial context rather than as a universal remedy. With this clarity in place, we can now turn to Article 9, where secure transactions are often misunderstood in a similar way, and where filings are frequently mistaken for creation rather than notice. That is the focus of the next chapter. For now, this principle holds. Paper does not create obligation. Structure does. Chapter 4. Article 9, Secure Transactions Explained Clearly. Introduction. Article 9 is often where confidence peaks and comprehension falters. This is the portion of the UCC that addresses secured transactions, situations where an interest in property is used to secure an obligation. Because it involves filings, liens, and priority, it is frequently assumed that invoking Article 9 creates power simply by recording paperwork. This chapter exists to correct that assumption. Article 9 does not create secured interests. It governs them after they already exist. What a secured transaction actually is. A secured transaction begins with a real obligation. There must be a debtor, a secured party, collateral, and value given. These elements are not symbolic. They are factual. Without them, there is no secured transaction for Article 9 to govern. The UCC does not invent this relationship. It provides rules for how it is treated once it exists. This is the first point where many misunderstandings arise. People assume that filing creates the relationship. In reality, the relationship must exist before any filing has meaning. Security interests are not created by filing. Filing is notice, not creation. A financing statement does not generate a security interest. It announces one that is already attached through agreement and value. Without attachment, there is nothing to perfect. Without perfection, there is nothing to prioritize. The sequencing is critical. Agreement leads to value, leads to attachment, leads to perfection, leads to priority. Skipping steps does not accelerate the process. It nullifies it. When filings are made without an underlying secured transaction, they do not fail loudly. They simply do nothing. Why filing is often misunderstood as power. Article 9 filings look official. They are recorded. They are searchable. They produce reference numbers. This gives the appearance of authority even when no authority exists. The visual weight of the process substitutes for the legal substance that should precede it. This is how filing becomes performative. Patrick Devine warned against confusing form with function. He emphasized understanding what systems respond to, not what appears impressive on paper. Article 9 is a clear example of why that warning matters. Where modern teachings went off course. Later interpretations of Article 9 often inverted the order. People were taught to file first and reason later. Self-created filings were treated as claims. Priority was assumed without attachment. The language of secured interest was used without any secured relationship to support it. This produced paperwork, not protection. And when challenges arose, the failure was blamed on technicalities rather than on the absence of substance. Why Article 9 requires restraint? Article 9 is powerful precisely because it is structured. When used properly, it creates clarity between competing claims. When used improperly, it creates confusion and sometimes liability. Filing without basis can undermine credibility, complicate legitimate transactions, and invite corrective response. This chapter exists to restore caution where confidence has been misplaced. Closing. Article 9 does not reward assertion. It responds to reality. When a secured transaction exists, the UCC provides predictable rules for how it is treated. When it does not, no amount of filing can manufacture it. Understanding this distinction prevents nearly every misuse of Article 9. With this clarity in place, we can now address one of the most persistent myths in private education. The idea that the UCC can override courts or compel outcomes simply by being invoked. That is the focus of the next chapter. For now, this principle holds. Filing is not leverage. It is notice, nothing more. Chapter 5. Why the UCC is not a court override. Introduction. Few misunderstandings cause more harm than the belief that invoking the UCC can compel a court. This belief often appears after someone learns that the UCC governs commercial transactions and that courts apply it in certain disputes. From there, a quiet assumption forms. If the UCC applies in court, then referencing it must control the outcome. This chapter exists to correct that assumption. The UCC is applied by courts, not enforced against them. Courts do not sit beneath the UCC. They apply it. The UCC is a body of state-adopted code that courts use when a case involves a transaction within its scope. It does not function as an external authority that can be invoked to override procedure, jurisdiction, or judicial discretion. A filing does not command a court. A citation does not compel a ruling. A notice does not bind a judge. The court determines whether the UCC is relevant, not the filer. Commercial code and judicial authority serve different roles. The UCC governs relationships between parties in commerce. Courts govern disputes, procedures, evidence, and remedies. When a commercial dispute falls within the UCC scope, courts use the code to interpret rights and obligations between the parties. When it does not, the UCC is irrelevant. This division of labor is intentional. The UCC standardizes commercial rules. Courts administer justice. Neither replaces the other. Why filings do not compel courts or agencies. A common belief is that filing something on the record creates obligation for anyone who later encounters it. This belief confuses notice with authority. UCC filings provide notice to other potential creditors about existing secured interests. That is their function. They do not create duties for courts, agencies, or third parties outside the secured relationship. Courts are not counterparties to UCC filings. Agencies are not obligers under them. Silence is not consent. When filings are directed at institutions with no commercial relationship to the filer, the system does not resist. It simply has nothing to respond to. Where the override theory emerged. The idea that the UCC can override courts grew out of two conflated observations. First, that courts reference the UCC in commercial cases. Second, that filing systems feel authoritative because they are official and recorded. From there, the leap was made that recorded filings must control outcomes. Patrick Devine did not teach this leap. He emphasized understanding jurisdictional boundaries and warned against assuming authority where none exists. The override theory emerged later, driven by certainty rather than structure. Why courts do not respond the way people expect. When people attempt to use the UCC as a court override, the result is often confusion or dismissal. This is not because courts are hostile to the UCC. It is because the UCC is being invoked outside its domain. Without a qualifying transaction and a dispute between proper parties, there is nothing for the court to apply. The silence that follows is often misinterpreted as evasion. In reality, it is alignment with scope. Closing. The UCC does not sit above the judicial system. It operates within it. When its boundaries are respected, it provides clarity and predictability in commercial disputes. When it is treated as a tool of compulsion, it produces disappointment and, in some cases, unintended consequences. This chapter exists to restore that boundary. With this distinction in place, we can now address another closely related misconception: the belief that filings themselves create money, discharge obligations, or manufacture value. That is the focus of the next chapter. For now, this principle holds. Law does not obey paperwork. Paperwork operates only where law allows it to operate. Chapter 6. Why filings do not create money. Introduction. After courts, the next assumption usually follows naturally. If a filing cannot compel a court, perhaps it still creates value. Perhaps recording a document, asserting a claim, or perfecting an interest produces money, credit, or discharge simply by existing in the system. This chapter exists to address that assumption directly. Recording is not capitalization. A filing is a record. It memorializes information about a relationship that already exists. It does not inject value into that relationship, and it does not convert paper into assets. Recording something does not change the underlying economic reality it describes. Money is created through capitalization, credit extension, or issuance by entities authorized to do so. These processes occur upstream of filings, not because of them. A filing reflects activity. It does not generate it. Why filings feel like they should create value. Filings feel consequential because they're formal. They're accepted by systems, time-stamped, indexed, and searchable. That formality can be mistaken for substance. When people see documents processed smoothly, it can feel as though something real has occurred financially. In reality, the system is doing exactly what it was designed to do: record information accurately. Acceptance of a filing is not validation of its content. Indexing is not endorsement. And silence is not agreement. Debt, discharge, and the misuse of language. One of the most persistent beliefs is that filings can discharge debt. This belief often arises from conflating notice with settlement. A debt is discharged only when it is satisfied according to the governing agreement or law. Filings do not satisfy obligations. They describe positions relative to them. Using language associated with money, such as value, credit, or set-off, does not create those conditions. The UCC does not treat terminology as operative action. Patrick Devine emphasized this distinction. He spoke about understanding how systems account for value, not about producing value through paperwork. The idea that filings themselves create money emerged later, detached from structure. Why system recognition is often misread. People sometimes assume that because a filing is processed by a system, the system has recognized a claim. In truth, most filing systems are content neutral. They do not evaluate truth, enforceability, or economic effect. They record what is submitted so that others may find it if relevant. Recognition occurs only when a filing corresponds to an actual transaction that the law governs. Without that correspondence, the filing remains inert. This is not resistance, it is design. The consequences of treating filings as money. When filings are treated as money, creating events, expectations rise that cannot be met. People wait for credit that never appears. They assume obligations have been neutralized when they have not. They interpret administrative silence as delay rather than as finality. The cost is not always immediate, but it accumulates. Misunderstanding deepens. Positions harden. Options narrow. This chapter exists to interrupt that cycle before it becomes personal. Closing. Filings do not create money. They do not discharge debt, generate credit, or transform obligation into value. They describe relationships that already exist, or they describe nothing at all. Understanding this restores proportion. With this distinction in place, we can now address one of the most persistent misapplications of the UCC. The idea that filing against oneself creates protection, control, or standing. That is the focus of the next chapter. For now, this principle holds. Paper records reality. It does not replace it. Caveat. This volume is about safety, not execution. This chapter and this volume exist for a specific reason. Many people encounter the UCC after being told that paperwork creates value, that filings unlock money, or that commercial language alone produces outcomes. When those promises fail, the instinct is often to look for a better filing rather than to question the premise itself. This volume interrupts that pattern. It does not deny that trust, estates, fiduciary roles, or secured relationships exist. It clarifies that none of them operate through shortcuts, and none of them function safely without proper capacity, sequencing, and understanding. Lawful action in commerce does not begin with filings. It begins with role. A trustee does not act as an individual. An executor does not operate as a claimant. A fiduciary does not move assets without duty, authority, and record. When people attempt to bypass those foundations by using the UCC as a substitute, they create exposure rather than protection. This volume is not telling you how to act. It is telling you why acting too early causes harm. Proper trust administration, executor authority, and fiduciary operation require education that comes before movement and outside of speculative filings. Those topics are addressed deliberately, in order, and only after the literacy foundation is complete. For now, restraint is not inaction, it is safety. Chapter 7, The Myth of Filing Against Yourself. Introduction. Once people accept that filings do not create money, a new idea often appears. If filing does not work against others, maybe it works inward. Perhaps filing against oneself creates protection, control, or standing. Perhaps naming oneself as debtor and secured party resolves conflict internally and produces a superior position externally. This chapter exists to explain why that idea persists and why it fails. Where the idea came from. The notion of filing against oneself grew out of a misunderstanding of secured transactions. Article 9 filings are meant to give notice of an existing secured relationship between distinct parties. Over time, that concept was extracted. If a secured party has priority over others, then becoming one's own secured party seemed like a way to preempt everyone. The logic felt elegant. It was also disconnected from how secure transactions actually work. Secured relationships require distinct parties. A secured transaction is relational. It involves at least two distinct legal capacities, a debtor and a secured party. Those roles are not symbolic. They reflect real obligations, real collateral, and real risk allocated between different interests. When the same individual attempts to occupy both sides without a genuine separation of capacity, there is no secured relationship to govern. There is no risk to transfer. There is no competing interest. There is no priority to establish. Without adversity or separation, there is nothing to secure. Why self-filing has no operative effect. Filing against oneself does not fail because it is prohibited. It fails because it is meaningless. The filing system records what is submitted. It does not evaluate whether the underlying relationship exists. When a filing describes a secured interest that has no substance, the record simply sits there, unacted upon, unrecognized, and unenforced. No protection is created. No priority is established, and no standing is enhanced. The appearance of form remains, but function never materializes. How this is often misrepresented. Self-filing is frequently presented as an internal accounting maneuver or a private declaration that does not require recognition to be effective. This framing misunderstands the nature of secure transactions. Security interests exist to resolve conflicts between competing claimants. They do not exist to create harmony within a single identity. When no external party is affected, the UCC has nothing to regulate. Patrick Devine did not teach self-filing as a solution. His emphasis was on capacity, and separation was about understanding roles, not collapsing them into a single assertion. The self-filing narrative emerged later, filling a void left by incomplete literacy. The risk of treating self-filing as protection. The danger of self-filing is not that it doesn't work. The danger is that it creates false confidence. People believe they are protected when they're not. They assume positions have been secured when nothing has changed. They proceed as though authority has been established when no one recognizes it. That false confidence often leads to further action. Banking attempts, claims, or assertions that expose the very vulnerability the filing was meant to prevent. This is not a technical failure. It is a sequencing failure. Closing. Filing against oneself does not create a secured position. It does not establish priority. It does not confer protection. It does not change how systems respond. What it does illustrate is how easily form can be mistaken for substance when literacy is incomplete. This chapter exists to remove that illusion. With this final misconception addressed, the pattern across the UCC becomes clear. Filings describe reality. They do not create it. Authority arises from role, relationship, and structure, not from paperwork alone. In the closing reflection of this volume, we will step back and tie these lessons together, reinforcing why understanding must always precede strategy. For now, this principle holds. You cannot secure what has not been separated. Caveat. Secured party language versus fiduciary authority. At this point, a clarification is necessary, especially for those who have studied Series 1 of the Patrick Devine curriculum. In that series, the concept of secured party status is discussed as part of a broader effort to help learners understand commercial relationships, notice, and priority. Within that context, the language served an educational purpose to illustrate how commercial systems recognize parties, interest, and hierarchy when disputes exist. What is often missed is that this language was never meant to be universal, mandatory, or permanent. More importantly, it was never intended to replace fiduciary authority. An executor, trustee, or fiduciary operating within their proper capacity does not require self-designation as a secured party to act lawfully or effectively. Their authority does not arise from filings. It arises from role, appointment, and duty. When the administrative process is handled correctly, an executor acts by authority of office, not by claim. A trustee operates through obligation and duty, not priority. A fiduciary manages and settles matters by responsibility, not assertion. In these roles, there is no adverse party to secure against internally, and no benefit gained by collapsing roles into a self-secured position. Doing so does not enhance authority, it confuses it. The secured party concept belongs in disputed commercial relationships, where competing claims exist and priority must be resolved. It does not belong in properly ordered private administration, where authority is already established by law, trust, or appointment. This is why attempting to complete one's position by filing against oneself is unnecessary and often counterproductive when acting as an executor or a fiduciary. This volume does not contradict Series 1. It refines how that material should be understood. As literacy deepens, reliance on symbolic positioning gives way to correct sequencing. What once appeared essential becomes optional. What once felt protective becomes redundant. This is not regression, it is maturation of understanding. Chapter 8. When UC filings are legitimate and when they are reckless. Introduction. By this point, one pattern should be unmistakable. Misuse of the UCC rarely comes from bad intent. It comes from misunderstanding when the code applies and why filings exist at all. Because filings look official, they are often treated as proof of position rather than as tools that reflect an already existing reality. This chapter exists to draw a clear line between the legitimate commercial use and reckless speculation, so that caution is no longer mistaken for hesitation. Legitimate UCC filings begin with real transactions. A legitimate UCC filing is downstream from reality. It follows a qualifying transaction where distinct parties exist. Value has been exchanged. Collateral has been identified. And a secured relationship has already attached. In those circumstances, filings serve a narrow and important purpose: notice. It informs other potential creditors about an existing interest so that priority can be determined if disputes arise. The filing does not create the relationship. It does not improve the substance of it. It does not substitute for it. When those conditions exist, filing is appropriate. When they do not, filing is noise. Recklessness begins when filing replaces substance. Reckless filings share a common feature. They attempt to replace structure with paper. They are made without an underlying transaction, without distinct parties, without collateral that can be secured, or without authority grounded in role. In these cases, filing becomes performative. It is used to signal position rather than record one. The danger is not that the filing is rejected. It is that the filer begins acting as though something has been achieved. This is where exposure begins. The real risks of improper filings. Improper UCC filings do not usually produce immediate consequences. They produce misalignment. They undermine credibility with professionals who understand the code. They complicate legitimate future transactions by creating confusing records. In some cases, they can be interpreted as false or frivolous claims requiring correction or response. Even when no enforcement action occurs, the cost is real. Trust erodes, options narrow, and later explanations become harder. These outcomes are rarely discussed by those encouraging speculative filings. Why fiduciaries do not rely on filing as authority. For executors, trustees, and fiduciaries, this distinction is especially important. Their authority does not come from filings. It comes from appointment, duty, and obligation. When administration is handled correctly, filings are not used to manufacture position. They are used sparingly and deliberately only when the underlying relationship requires notice within a commercial context. Attempting to supplement fiduciary authority with speculative filings does not strengthen it. It confuses it. This is why restraint is not a delay tactic. It is a safeguard. Commercial filings versus fiduciary administration. At this point, an important distinction must be made to prevent one of the most common sources of confusion in private study and administrative education. Commercial secured transactions, fiduciary administration, and administrative settlement are different systems with different authority structures. Most confusion arises when people try to use tools from one system inside another. The Uniform Commercial Code governs secured commercial transactions between parties engaged in commerce. It provides rules for negotiable instruments, secured interests, collateral, and priority between creditors. UCC filings exist to give notice of an existing secured relationship arising from a commercial transaction. Fiduciary administration operates under a different framework. Executors, trustees, and fiduciaries do not derive their authority from commercial filings. Their authority arises from appointment, office, duty, and the governing trust, estate, or administrative structure under which they operate. An executor acts by authority of office. A trustee acts by obligation and duty. A fiduciary acts by responsibility and record. None of these roles require UCC filings to exist, and none of them are created through secure party filings. Filing a financing statement does not appoint a trustee, does not create an executor, and does not establish fiduciary authority. Estate administration and fiduciary management are primarily matters of record keeping, accounting, notice, duty, and proper administration. These processes involve maintaining ledgers, minutes, notices, distributions, and administrative records. They are administrative and fiduciary in nature, not secured transaction filings. This is where many people make a critical mistake. They attempt to use UCC filings as a substitute for proper administration, believing that filing creates authority, protection, or control. In reality, filings do not replace structure, duty, or administration. They only provide notice of a secured interest when a qualifying secured transaction already exists. Commercial filings belong to commercial secured transactions. Fiduciary authority belongs to fiduciary office and administration. Administrative settlement belongs to accounting, record, and duty. These systems sometimes interact, but they are not interchangeable. Understanding this distinction prevents a major sequencing error. Many people are taught to begin with filings, claims, or secured party language. In reality, proper sequencing begins with role, structure, administration, and record. Only after a real commercial secured transaction exists would a UCC filing become relevant. When the systems are kept in their proper place, everything becomes clearer. Commercial law governs secure transactions. Trust law governs trustees. Estate law governs executors. Administrative law governs agency and treasury processes. Private association law governs private membership organizations. Each system has its own authority, procedures, and records. Problems arise when someone attempts to use tools from one system to perform the function of another. This is why fiduciaries do not rely on filing as authority. Their authority already exists through appointment and duty. Proper administration, accurate records, and lawful process establish authority far more effectively than any filing ever could. Understanding the difference between commercial filings and fiduciary administration is not a minor technical detail. It is a foundational literacy issue. When this distinction is clear, most misuse of the UCC disappears, and administrative processes can be handled in their proper order. Paperwork does not create authority. Authority determines what paperwork matters. Where modern teachings went too far. Many modern teachings collapse all UCUs into a single narrative. File early, file broadly, and file defensively. That approach ignores the central principle of the code. It governs relationships, not declarations. Patrick Devine emphasized comprehension and sequencing. He did not teach indiscriminate filing. The expansion of filing into default strategy came later, driven by the belief that visibility itself creates leverage. This chapter restores the boundary that belief erased. Closing. UCC filings are not inherently dangerous. They are content sensitive. When they follow real transactions and proper authority, they function as designed. When they are used as substitutes for structure, they create risk rather than protection. This chapter exists to remove pressure, not to file better, but to file only when appropriate, and often not at all. With this final distinction in place, the purpose of this volume becomes clear. The UCC is not a shortcut, a weapon, or a declaration of status. It is a framework that rewards accuracy and punishes assumption. Closing reflection. Structure before strategy. This volume was not written to discourage engagement with the UCC. It was written to restore proportion. The Uniform Commercial Code is neither mystical nor adversarial. It is a framework designed to bring predictability to define commercial relationships. When those relationships exist, the code functions quietly and effectively. When they do not, the code remains silent, not as a rejection, but as a boundary. Across each chapter, the same lesson has repeated itself in different forms. Filings do not create authority. Language does not substitute for structure. Paper does not override role. Misuse of the UCC almost always begins with good intentions and incomplete literacy. People are taught to act before they are taught to understand. Filings are encouraged before relationships exist. Strategy is emphasized before structure is established. This volume interrupts that pattern. For executors, trustees, and fiduciaries, the takeaway is especially important. Proper authority does not need to be supplemented with symbolic positioning. When administration is handled correctly, restraint is not weakness, it is alignment. If you leave this volume with fewer urges to file and a stronger understanding of why, it has done its work. The UCC is not something to wield, it is something to understand. And understanding, when it comes first, prevents harm that cannot be undone later. What's next? Introducing Volume 7, Private Process Myths. Why popular claims fail in the real world. With the UCC placed back into its proper context, another layer of private education needs to be addressed. Not statutes, not codes, but claims. Volume 7 focuses on the recurring narratives that circulate widely, sound convincing, and consistently fail when tested in real-world settings. These claims often borrow language from legitimate systems, but they detach that language from structure, process, and authority. This volume does not name influencers or target individuals. It examines patterns. Among them, claims that bills are prepaid, misuse of OID and 1099 forms, the Treasury Direct account narratives, birth certificate monetization theories, why certain filings are dismissed by judges immediately. Each chapter will examine why these ideas persist, what assumptions they rely on, and why they collapse under even minimal scrutiny. The focus is not on ridicule or debunking by assertion, but on restoring discernment. Volume 7 continues the same discipline you see here. No shortcuts, no performative action, no promises that reality does not support. By the time you complete it, the goal is not to replace one explanation with another, but to recognize patterns early enough that you no longer need explanations at all. Literacy, once established, makes myths unnecessary. When you're ready, Volume 7 begins by examining the first and most common claim and why it fails the moment structure is applied.
All right, so thank you for reading tonight. And that's the end of Volume 6. Next Tuesday on, what is it? March 31st will be the last volume for the Foundations and Risk Literacy class. And once again, we're starting April 7th with our family office class. For that one, you do need to be a member. So go ahead and visit our website at www.privatepathhrsolutions.com. Join as a member, and then you'll be able to register for the event. So it's starting soon. Make sure you head over to our website and get signed up. And please remember to like, subscribe, and share this video with somebody that you feel would get any use out of it. Have a good night. All right, I've stopped the recording. Stop.